The Silva Borges v. Bondi out of the First Circuit. First Circuit doing work. Also very important in this day and age. Look, you might have a client who has no case. That is, if they are a non-citizen. If ICE can, in fact, meet their initial burden to establish alienage. It's always ICE's initial burden. Now, don't get me wrong. If your client's detained, this might not be a game they want to play. And they're trying to detain everybody, but these cases are percolating up when people weren't detained. Fire me. And mind you, if you get it terminated, your client can't be detained anymore. It's always DHS's burden to prove alienage before anything, even for 212 charges.
Well, let me pause that. What's the situation right now going on in court where they terminate the case and as soon as they walk out, they pick him up? Wouldn't that be the scenario that happens?
It's not. You're right. It's not good, but it does presuppose that DHS can establish alienage in that circumstance. But then you're arguing that in expedited removal proceedings with ICE, yeah, in this case, if it's terminated, can they just detain them? They probably can. That termination is not so great now for these people. It's a catch-22. Of course, that also assumes that ICE can establish alienage, but I don't think ICE and expedited removal will care quite as much, and then you'd have to do an emergency petition for review that to the circuit. So yeah, this isn't always great, and you attorneys should be very careful, but that doesn't mean that First Circuit isn't making great law right now. Agreeing with the Sixth Circuit that ICE's initial burden under the statute and old Supreme Court case law is not just clear and convincing evidence, but clear, unequivocal, and convincing evidence. And that's based on the language of the statute and Supreme Court precedent, and they mean something different. Quote, unequivocal taken by itself means proof that admits of no doubt. A burden approximating, if not exceeding, the use in criminal cases, end quote. That is a big deal. That is a big deal. And the First Circuit has now issued this decision and the Rosa decision before it, which I also might have talked about on your show, talking about how these EARM summaries, summaries that DHS is filing in immigration court that include an I-213 within them are not necessarily cutting it, especially when you can pinpoint all the inaccuracies in that filing. So the Sixth Circuit is another circuit that has recognized that clear, unequivocal, and convincing evidence is a higher standard than clear and convincing. That's holding the agency to its burden. And here's the First Circuit really just going all in.